Welcome to White & Case. It's quite an exciting opportunity for the firm to group with Sciences Po. We haven't done enough of this, and we appreciate the opportunity to be able to do so. You've seen from the programs, I'm not going to read them out to you. I think we have a pretty good program going this evening. Public, private interest, public interest. What are we really talking about here? We're not necessarily going to find a lot of the answers, but we hope we're going to be able to stir up enough discussion, at least, so that the issues at least become clearer, because they tend to get a little lost in translation if one isn't careful. When you think about just the whole idea of divide, I thought, given that I've been in France for so long, I should probably look up and see what it means in English. The whole idea of a divide, and I quote really, it's just to say it's a difference or disagreement between two groups, this from the Oxford Dictionary, but producing tension. And that's exactly what we're talking about. The papers are full of this now, obviously more often in the specialist press, but I think also in the popular press you'll now see that people really want to try and understand. I don't know if people recall years ago in the New York Times there was an article about the arbitrators and described in very damning terms as men in dark suits who meet behind closed doors and make decisions that may decide the livelihood of thousands of people. And that's a little bit what we're seeing now. The whole thing is coming back to the fore. So when we talk about it, I had a quote. I should say I found it, but I didn't. Thank you, Fiona. It was something that we found about James Crawford. James Crawford, as you may know, has two great claims to fame. Three, actually. One, he's just been appointed to the International Court of Justice. Two, he's from Adelaide, like I am. And three, he taught me. But what he did say, which I thought was quite good, and he was talking here more about the dissents between arbitrators, but I think that the same thing applies when one is dealing with the type of issues we have here. And he described it as the carpet looks very much as if different people have started from different ends without many common threads. A crazy quilt rather than a Persian rug. Let's hope that we can at least start to unravel some of these Gordian knots while we're here. And with that, I'll pass the microphone.
Well, thank you very much. Very briefly, I'd like to say thank you to White & Case in the name of Sciences Po Law School and perhaps specifically the clinic for hosting this event. It's an extremely generous gesture. I think that the White & Case have played clearly a key role in the organization. But my specific thanks go to their support for Robert in organizing this project and drawing attention in the public debate to something that's obviously extremely controversial, highly sensitive. I won't say any more on the substance. It's already very well been summarized by, or at least opened by Michael. I'd just like to draw attention on the side of Sciences Po, to the implication of the clinic at the law school, about which many people are unaware, but it's actually very active. And I think there are at least three points on which the clinic and big law do actually enter into contact. One is a certain number of cases in which the clinic is investing in pro bono work. So, for instance, there has been a team with the Carter Center in the Congo, Haiti, on a project with NYU and Harvard. And of course, the clinic is extremely happy to receive support for its projects from law firms. The second point on which the clinic is working, and which is perhaps of interest there again to large law firms, is its project with the Barreau de Paris, which is actually also supported by Linklaters, on social responsibility of law firms. So, la responsabilité sociale des cabinets d'avocats. I think it's a good topic. And the third point on which the clinic is working, which is also of interest to law schools, is the question of legal aid and access to justice, policy reform. And here the clinic is actually working with France Terre d'Asile on questions of access and finance. So thank you very much, and well done again to Robert Houston for organizing this event and the investment that he has put into it.
Hello, my name's Michael Polkinghorn. You may remember me, I was taught by James Cook. I'm now here to introduce our keynote speaker. One is always mindful of the fact that introducing a speaker, one should be polite. This is an easy one. Our speaker this evening, Catherine Rogers, is someone that I have known for 20 years, I think. It started with us working in a law firm when she was in Hong Kong, I was in Vietnam, and we were just calling up each other and saying, did you see what he did? You don't need to know what happened to that law firm, but let's just say it's not around anymore. But Catherine, so moving off from the personal to the professional, I think a number of you will know Catherine, or know of some of the fantastic work she's done. She's, at present, to give you a couple of ideas, Ethics in International Arbitration, a book that's been crying out to be read now for years and years, because we all come from such a different set of backgrounds, and you can just find some of the most obvious points where people are indignant because of misunderstandings. This is the sort of book that should probably help clear the way, one hopes, for people to actually get it right and not be accused of unethical behaviour when frequently it's a question of ignorance. At least that's what I pled. A couple of points also just to add to this. I mean, Catherine is presently, I think you're professor at both Penn State and Queen Mary. You have, and I'm just, you can see this, that's her achievements, and that's the short version. You're the reporter for the restatement of the US law of international commercial arbitration. And the one I found very interesting, you're co-chair with William Rusty Park, of the ICA Queen Mary Task Force on third-party funding. You may ask, third-party funding, where does that tie in? Well, as some of you may know, that is an area which is becoming controversial and is basically inviting and inciting a great deal of comment on just how does that stand in the whole scheme of things. So again, work that's crying out to be done. With that, I think I will pass the microphone, Catherine.
I am going to, in the brief time that I have, which is about 19 and a half minutes at this point, to try and frame a few concepts, or at least challenge you to think differently about some of the terminology that I think will be described later. I will also try to bring in, on the private side, challenge us to think a little bit more specifically about how so-called private commercial international arbitration affects some of the discussions that we'll be having about the more public side. So I'll explain the metaphor of the duck rabbit in just a moment, but as many of you know already, one of my primary areas of interest is both ethics and specifically the ethics of arbitrators. So to the extent that I have a rabbit in this race, it's going to be arbitrators, and that's where I'll end up. But to start with, what I'd like to do is challenge the entire premise of this conference, this so-called dichotomy between public and private. And there's not quite a syllogism, but something like a syllogism that's often used, which is investment arbitration is public. Therefore, public, it needs to be transparent. Commercial arbitration is private. Therefore, we don't really care about transparency. I think that is where this dichotomy, or how this dichotomy is oftentimes framed. But what I'd like to do is A, reconceive the public side of the private and the private side of the public, and argue that increased transparency in international arbitration, in international commercial arbitration, particularly with regard to arbitrators, has important benefits also for international investment arbitration. So with that, and I'm going to go slightly, to make the rabbit quack. I hope everyone can see the sort of duality that we're talking about here. If you look at it from one side, it looks like a rabbit, but if you look at it from the other side, it looks like a duck. And the trick, I think, is to squint hard to see both the duck and the rabbit at the same time, whether it actually quacks out loud or not. Okay, with that, I'm going to actually do a little out of order from where I started from. And I'd like to start with what sounds like a counterintuitive proposition, right? The public side of private, so-called private, international commercial arbitration. And this is something that I've written about and is also delved into in the book in some fashion. But one of the things that's oftentimes overlooked when we describe so-called private arbitration is that it generates a number of public and quasi-public goods, or what might be called club goods. So what's a club good? This is a term that's used by economists. They had to come up with something confusing to describe something relatively simple, and then they choose adjectives to make it even more difficult. It's a non-rivalrous but excludable good. What does that mean? Think of a toll bridge, okay? It costs a lot of money, takes a lot of expense to build a toll bridge, but once it's up, anyone can use it as long as they pay that little toll. Well, international so-called private arbitration has built a number of really important toll bridges that make international trade work. The ones that I'll point to most obviously right now are skilled arbitrators. These are incredibly talented people who are able to operate in a multidimensional fashion, and they have skills that are not readily replicable by even very intelligent people who speak multiple languages. Why? Because their skills are developed over time. I would include, as many of you are here in the room, International Arbitration Council. We are in the process, almost every law school in the world, trying to figure out how do we train, what does it mean to train lawyers to be global lawyers? Okay, well, like the famous phrase from a U.S. justice about pornography, I know it when I see it, okay? We might not be able to define what a global lawyer is, but I know it when I see it. And certainly when I look around this room, when I look at international arbitration, these are global advocates. They are people doing comparative law in real time. They are people who necessarily have to adapt to multiple overlapping legal cultures, to understand multiple overlapping legal systems, okay, and to improvise. So I really like James Crawford's quote at the beginning about it being a crazy quilt, but that is what I think has made international arbitration work, and that is one of the skills, being able to do a crazy quilt, that I think has developed in council that are there. In addition, we have amazing institutions. The number of complex problems that arbitral institutions deal with, including drafting new arbitral rules to run these processes, is, I would say, a club good, a really important bridge that's been built. Yes, it requires a toll to use, but let's not overlook the value of it. But in addition to these so-called club goods, I would say international commercial arbitration has also developed a number of what we'd call, or what economists call, public goods. Again, non-excludable, but non-rivalrous in this instance. So it's the new bridge, but without a toll. Okay, it's the bridge that connects everything, but you don't have to pay a toll to use it. Now, we don't usually think of international arbitration as creating so-called public goods, but it has. So-called private international arbitration has developed a number of important transnational laws or rules. The most important of them, I would say, are procedural rules and practices. And here I'm going to take a footnote to a really excellent chapter by John Crook in a book that I was privileged enough to have been the editor of, where he argues that actually international arbitration is better at fact-finding than so-called public international tribunals like the ICJ. Now that James Crawford is on the ICJ, maybe we'll see some development in that area. And the reason, he says, he actually has some very specific reasons why arbitration is more sophisticated and nuanced in its ability to fact-find, and it takes it right back to those skilled counsel we were talking about, because arbitration usually pits skilled attorneys against each other in an incredibly intense fact-finding adversarial setting, which is different than some of the traditions in traditionally public adjudicatory settings, most often where you would have diplomats from the various countries representing their states, okay, and not necessarily trained in the rigors of fact-finding and the nuances of evidence. In addition, international private arbitration, so-called private arbitration, has generated substantive rules. In fact, some of the UNCITRAL principles, and in fact also the CISG, much of the decisional history that was distilled down or codified into those documents was generated by so-called private arbitral decisions. Okay. In addition, and this is a slightly more nuanced or abstracted public good, if you will, arbitral authority and a transnational rule of law. Now that we have international arbitration that's seen as reliable and a resort, investors, not just investors in terms of investors in investor-state arbitration, but international trade can take place with the confidence known that if a dispute arises, it can be resolved. Now that's really important when you think about places where there is no such assurance. And I say this, for example, being on the Court of Arbitration of the New Jerusalem Arbitration Center. The whole concept behind that center is that two groups, a little more hostile to each other than the normal trading part, normal people on different sides of a trade transaction, but they didn't have any place where they could resolve the disputes. Israelis couldn't go to Palestinian courts. Palestinians didn't want to be in Israeli courts. And just the creation of a dispute resolution mechanism was incredibly liberating to the transactions that had to take place. You no longer had to have a suitcase of money at the border, okay, or a limited series of transactions. You didn't have to have workarounds because you know you had effective dispute resolution. That effectiveness is itself, I think, a valuable good that enhances the ability of international trade to flourish. And the promise of enforceable results goes with that. It's an incredibly resilient institution, international arbitration generally. The enforceability of its results and the compliance with it by national courts, the willingness of national courts to cede this incredibly important function, adjudication, okay, to international arbitration, and then nevertheless to enforce it at the end, I would say demonstrates a level of international cooperation that's truly astounding when you compare it to other things, perhaps second only to like airline compliance, okay, with the seatbelt rules that we all have to listen to each time we get on an airline. Now with that, let me go back to investment arbitration's private side, okay. I think investment arbitration, and this is both a point on which it's criticized, and I would say to the extent it has strengths, the source of many of its strengths. Investment arbitration really stands on the shoulders of commercial arbitration and the structures and the best parts that it built. And to the extent that we talk about dissecting or reconsidering investment arbitration, one of the things to consider is what aspects of its strengths come from a so-called private side, because we do those are the things that are the targets when people talk about reform. But as I've just suggested, maybe not all of them are as bad as they sometimes get characterized. So first of all, investment arbitration, blatantly relies on more and more explicitly commercial arbitral rules. Okay, it used to be that only ICSID was in the conventions. Now the ICC, the SCC, and of course UNCITRAL. UNCITRAL was the basis for the ICSID rules. Okay, these rules were originally developed. So when we talked about the public goods developed by international commercial arbitration, these are some of those goods, and they've been in a sense borrowed, appropriated as a basis for investment arbitration. In addition, and I think this is an important consideration, more and more treaties are allowing parties to choose whether to go to ICSID or to go expressly to so-called commercial arbitral institutions. But not only that, you also have concurrent jurisdictions, particularly in extractive industries or large infrastructure projects, two areas that we would care a lot about with investment arbitration. Investors have an option sometimes when they're in a contract with a state-owned entity, either to pursue a so-called commercial arbitration or to do investment arbitration. So investment arbitration in some of these most important cases is directly competing with or being compared and contrasted with as an option during forum shopping with so-called private international arbitration. In addition, and this is again one of the areas where our international commercial arbitration has generated public goods. International investment arbitration would not, in its best moments, be as strong as it is if it could not build on the fact-finding techniques and procedures that were developed by international commercial arbitration. This goes back to John Crook's comment. Why? Because if we relied on the procedures and practices that existed for purely public tribunals, okay, I don't think they would be nearly as rigorous. And why is that? In part because investment arbitration borrows what I think is in international commercial arbitration's greatest assets. Now, this is also a point of contention, admittedly, but it's the same arbitrators and the same counsel that come over from international commercial arbitration that are responsible for adjudicating the cases in investment arbitration. Now, one of the things that's interesting, I think, as a trend that we're seeing not only in investment arbitration, but also in so-called purely public arbitration between states, for example, is that more and more states are relying on outside counsel, including at the ICJ. And when states are choosing to adjudicate their border disputes, more often we are seeing them go to arbitration. Okay, for a number of the reasons why arbitration is a crazy quilt, and for a number of the same reasons why investment arbitration borrowed some of these features, some of these public goods that were created by international commercial arbitration. So we'll zip back through this one and go to the next thing I want to do, and I challenge, this is an opportunity to both be corrected and hopefully to perhaps frame some of the discussion that will come. So transparency is an incredibly opaque term, okay? We use it all the time, and we all think we know what it means, okay? And I'm going to go quickly through this because it's vocabulary, and nobody likes vocabulary. But I think that there are three distinct concepts that are oftentimes spoken about interchangeably, but are important, especially when we talk about reforms to investment arbitration, to distinguish. Okay, the first one is transparency. What does it mean? It means, I think, for interested parties to be able to understand the rules that are going to be used to adjudicate the dispute. And I put interested parties in quotation marks because that group might change in a purely private contract dispute between two commercial entities. The interested parties might actually just be those parties. Okay? But in any sizable dispute, and certainly when a state is involved, that pool expands dramatically. Okay? And the purpose of making the rules that are going to govern the procedures available and clear is that it facilitates monitoring of the process, and particularly of the adjudicator. Okay? If you know that it is permissible or expected that you should have oral hearings, and the adjudicator says, no, I'm not going to allow oral hearings, okay, we would know that that's a basis, in a sense, for criticizing. But if there's no transparency about what rules apply, what the baseline is, it's difficult to assess. Public access, I'm going to skip over very quickly. I think particularly in investment arbitration, this idea is used coterminously with transparency. I think it's a tool for promoting transparency, but I think it is actually something different, and it has different political connotations that I won't go into right now. And the third area, which I think is also very important, but somewhat new, difference, is the idea of disclosure. Okay, and disclosure, unlike transparency generally, disclosure focuses on the substantive information. Now, why do we need disclosure? Because it allows us, for example, to reassess institutions and to make strategic decisions. So, for example, with transparency, I would say one of the most important advances in this area might be considered, in my area, which I am near and dear on the arbitrators, is the IBA rules on conflicts of interest that were originally promulgated in 2004. Okay? Now, we don't think of those as promoting transparency, but look what they did. And I'm not talking about transparency because the arbitrators have to disclose information. I'm talking about breaking through the opacity of, wait a minute, is that a conflict? Would I have to disclose that? Could I be challenged for that? Now there are very, very clear rules and guidelines about when something has to be disclosed and when it might be the basis for challenge. Now, we might disagree with which lines are drawn and where, okay, either about the challenge or about the disclosure, about the disqualification. But the fact that those rules are now clear gives us a baseline for evaluating when there's a non-disclosure. Was it appropriate or was it not? Otherwise, it's just an endless debate about whether, an intersubjective debate. Moreover, when there are outcomes that are disclosed, for example, a non-disclosure of a supposed, what's called now an issue conflict, okay? The original standards under the IBA guidelines said issue conflicts, that's green list, that's not a problem, arbitrators don't need to disclose it. But once we have disclosure or publication of awards where these issue conflicts were not disclosed, we can have a more robust debate about revising the original rules, okay, that said whether they needed to be disclosed or not. So I think disclosure and transparency work together to provide a baseline for increasing clarity, okay, and for measuring behavior, okay. Now I'm going to transition. One of the areas that I think, even if I think that the IBA guidelines did a tremendous job in helping us understand when arbitrators need to disclose certain information and when they might be rightly challenged based on those disclosures, I would say arbitrator selection is still one of the most opaque and non-transparent parts of the process, and particularly, and this is what's somewhat shocking, for parties. And this has become a particularly significant area of concern as state parties in investment arbitration are more active, and that they haven't necessarily always been, at least initially, part of this inside group of skilled international arbitration council. And I'm going to take 3 minutes to explain to you why I think this process is so opaque and what needs to happen in terms of transparency and increased disclosure to make it work better. So for those of you, I'm assuming most of you know this, I know we have some people who might not be as inclined, but because arbitrators have so much discretion over really fundamental things like how long are the submissions, sometimes even what is the seat, what is the governing law, how many witnesses can be called, how long will the awards be decided, will amicus be permitted, okay? Because they're in charge of so many decisions like that, the moment at which you're choosing an arbitrator as a party is one of the most sensitive moments in the entire case. And the way you choose them, and this is the part that not everyone outside the community knows, the way you choose an arbitrator, you make your lists of your favorite people, but then you get on the phone and you call everyone you know, or you write emails to everyone you know saying, what do you think of this person? Have you appeared before them? Have you sat with them? What do you know about them? Are they someone pretty willing to grant interim relief? Are they someone who's opposed to extensive document production? Do you think they'd entertain an expansive view of jurisdiction? Okay, think about how profound those questions are. Okay, and those are areas where increased transparency and certainty is sure to come in the future, but right now it's all in the hands of arbitrators. And listen to what I said. How do you find that out about the arbitrator you're trying to select? You call up your friends or you write them an email. Now, what does that mean? And this is actually based on an anecdote told to me by a very famous arbitrator who says he gets these inquiries all the time. And he said, as we all would, that how he responds to them depends on how well he knows the person asking. Okay, think about what that means. It means that the opposing counsel in the same case with totally opposite strategies could call the same person and ask them the same question about the same arbitrator and get 2 different answers. Okay? At this most sensitive selection moment, this most sensitive moment in the entire arbitration, the selection of the arbitrators. Okay, that is a profound information asymmetry and an area where additional transparency is very, very much needed. Not just about conflicts of interest, but about the essence of selecting an arbitrator. So I think that's my timer. I'm going to take 1 more minute before I go on my way. Just to tell you briefly about a project that I've started to, I believe, remove some of the opacity in this process. And that's what I call arbitrator intelligence. This is quite literally my last slide, so you just have to be patient for about 45 more seconds. Right now we're in a very initial startup phase, but it's a nonprofit organization aimed at collecting information about arbitrators. The purpose of collecting this information is hopefully to render the process more fair and transparent and arbitrators more accountable. And the idea is that we're solving a transparency problem or lack of transparency problem and a fairness problem with making the market of information more accessible. The idea is that information asymmetry, the fact that parties don't have equal access to information about arbitrators, we're trying to even that out, okay, to create a baseline. It won't be a perfect ceiling where everyone has exactly the same information, because you can always add more, but we'd like to see an even floor. Market-based accountability for arbitrators. Again, why do we want disclosure of information? Because it helps us, based on certain criteria and rules that we know, evaluate performance. The added benefit, which I think goes to all, and this is part of why it would be something beneficial no matter what side you're on, is more, if you don't have something like this, you essentially recreate this information every single time. So even well-heeled parties who have lots of people they can call, this can be time and cost effective for them. And more than anything, I think it'll make the arbitrator selection process more accurate. I'll close on this just to say the accuracy issue is much more important for parties that are not connected to multinational law firms and multinational corporations, which in the investment context tends to be the states. And for that reason, I think increased transparency in the arbitrator selection process, particularly since arbitrators are really the lightning rod for all of these concerns that people seem to articulate about investment arbitration, strengthening the processes through which they are selected, I think can go a long way. So with that, once again, let me congratulate both White & Case and Sciences Po on a wonderful program, and I look forward to hearing how all these ideas are developed by our speakers. Thank you.
Good evening, and thank you, Professor Rogers. My name is Robert Houston, and I'm here today with Jeremy Lajolie, Miglina Angelova, and Evgenia Letisheva from the Sciences Po Law School Human Rights Clinic. To get the ball rolling for our first topic this evening, these students bring you a thought-provoking performance of a procedural hearing in a mock arbitration. This performance arose from the students' interest in the recent ICSID case, Border Timbers v. Zimbabwe, a case in which Swiss investors pursued claims of expropriation against the government of Zimbabwe in the context of its land reform program. In Border Timbers, the tribunal was forced to make some tough decisions on whether to allow the intervention of a non-governmental organization acting on behalf of indigenous communities to pursue claims to traditional land holdings, the same land the claimant argued had been expropriated by the respondent. In that case, the tribunal ultimately decided against allowing intervention by the NGO and the indigenous communities under the ICSID rules. In today's presentation, the students imagine how a case with similar facts might have been heard if it were not governed by the ICSID rules, but rather by the UNCITRAL rules, including the UNCITRAL rules on transparency in treaty-based investor-state arbitration.
Good evening, everyone. Thank you for being here. My name is Miglena Angiova, and it's my great honor to be sitting here as an arbitrator. I would like to ask each counsel to present himself, herself, and explain on whose behalf he or she is pleading. Claimant, I would like you to begin.
Good evening, Madam Arbitrator. Good evening, Mrs. Letisheva. I am Jeremy Lajley, and I represent the claimant, Frontier Forest Limited, which is a Swiss company. The present arbitration concerns the respondent's expropriation of properties on which the claimant operated timber plantations in the state of Zimbabwe. During the course of Zimbabwe's land reform program, the government forcefully acquired these properties. The claimant requests damages on the basis of the unlawful expropriation which it has suffered, consistent with the bilateral investment treaty, or as you may know it, the BIT, signed between the states of Switzerland and Zimbabwe.
Thank you, Mr. Lajley. Respondent?
Good evening, Madam Arbitrator. Good evening, my esteemed colleague, Mr. Lajley. My name is Evgenia Letisheva, and I am pleading today on behalf of the respondent, the State of Zimbabwe. As we have publicly explained, the State of Zimbabwe has implemented in its state's land reform program to address the systematic dispossession and alienation of land from black indigenous people during the period of colonial rule. We look forward to demonstrating in our presentation of the merits that the sovereign state of Zimbabwe has acted in accordance with its international obligations and owes no compensations to the claimant.
Thank you, Ms. Letisheva. As a practical matter, have you reached any agreement on the allocation of time?
No, we haven't reached any agreement, and we would like to leave that matter to your discretion.
Thank you for your trust. I suggest structuring the present hearing in an adversarial manner, addressing issue by issue. Do you agree with the structure?
Yes, Madam
We agree.
Arbitrator.
Okay, so the first issue to be considered is the application of the UNCITRAL transparency rules to this dispute. I would like claimant to begin first.
Thank you. I will first make the case that the transparency rules should not apply in this case. The BIT was dated March 31st, 2014, and Article 1.1 of the transparency rules sets out that they should apply to treaties concluded on or after April 1st, 2014. As a result, the transparency rules simply should not apply in this case. Moreover, as stated in the request of arbitration, the transparency rules application would constitute a gross violation of the party's original intent. There may have been a contingent delay in the signing of the document, but this does not impact the party's intent to apply the UNCITRAL rules without the transparency addition.
Thank you, claimant. I would like to hear what respondent has to say.
Thank you, Madam Arbitrator. My esteemed colleague just stated that the parties intended to conclude the treaty on March 31st, but the bilateral investment treaty was nonetheless signed on April 1st, 2014, at 10 past midnight to be specific. Moreover, the states did not undertake to derogate from the applicability of the UNCITRAL transparency rules, so we are urging the tribunal to stick to the facts and to recognize the applicability of the transparency rules to the treaty, which was concluded on April 1st, 2014.
Understood. This is a very delicate issue. The bid was dated March 31st, but signed April 1st. I would like to proceed on the assumption that the UNCITRAL transparency rules apply to this dispute. I will make my decision in the final order. The second issue I would like to address is the request of the NGOs and indigenous communities' right to participate as third persons. Claimant, I would like you to begin.
For the sake of expediency, we agreed to proceed as if the transparency rules applied in this hearing. But Article 4.3 of these same transparency rules unambiguously sets out that when considering submissions by a third person, the tribunal is bound to assess whether this person has a significant interest in the arbitral proceedings and whether such submission would assist the tribunal in the determination of a relevant factual or legal issue. Madam Arbitrator, without touching on the merits, this is a private dispute between the state of Zimbabwe and a Swiss company. Since the NGO and the indigenous communities are not parties to this dispute, they neither have a significant interest nor could they assist the tribunal in the determination of a relevant factual or legal issue. The human rights claims by indigenous communities pertain to human rights law. Moreover, there is no obligation for a tribunal to import legal elements from treaties other than the BIT. As my esteemed colleague contends in her brief, this has been recognized notably through the Grand River versus United States of America decision.
Okay, I see your point. Counsel for respondent?
Well, to the extent that these proceedings may affect the legal claims of the communities and the NGOs that represent their interests, we contend that their third-party submissions do fall within the scope of the dispute. To suggest the opposite, my esteemed colleague just quoted Article 4.3 of the UNCITRAL transparency rules. But if I may, Madam Arbitrator, the NGO and indigenous communities have a significant interest because these proceedings will raise issues related to the right to the lands on which claimants' properties were located. As a result, their submission will assist the tribunal in the determination of a factual or legal issue in this case and should be allowed. And further, the UNCITRAL transparency rules should be construed in accordance with Article 26 of 2007 UN Declaration on the Rights of Indigenous Peoples, which states, and I quote, "Indigenous peoples have the rights to the lands, territories and resources which they have traditionally owned, occupied or otherwise used or acquired." Switzerland, as well as the state of Zimbabwe, have both voted for the adoption of this declaration, and by doing so, presumably intended to recognize these rights.
Counsel, are there any examples of tribunals that have dealt with such issue before?
Yes, Madam Arbitrator. A number of previous arbitral tribunals have recognized the relevance of the public interest in investor-state arbitrations, including the famous Methanex versus United States of America case, in which the tribunal noted that the substantive issues raised far beyond those raised by the usual transnational arbitration between commercial parties. As recently as 2008, the tribunal in Bywater versus Tanzania case relied on Methanex in deciding to allow submissions from interested, non-disputing parties, since the dispute raised a number of issues of concern to the wider community in Tanzania. Perhaps most importantly in this case, Madam Arbitrator, participating through a brief of amicus is the indigenous sole and unique opportunity to be heard.
Thank you, Counsel. I'll take these arguments into consideration and make my decision in the procedural order. You may submit briefs within 30 days. Moving on to the next issue. Given the sensitive nature of some of the materials provided, I would like to know what your positions are with respect to confidentiality. Claimant, please.
Our position on this point is quite clear, Madam Arbitrator. I will first underline the fact that all exhibits to key arbitration documents must be kept confidential pursuant to Article 3 of the Transparency Rules. Furthermore, disclosure provisions are subject to the strict limits set out in Article 7 of these same Transparency Rules. Furthermore, these Transparency Rules safeguard the broad category of confidential business information. So, as detailed in our brief, Madam Arbitrator, we request that all business information be redacted from any public documents.
Thank you, Counsel. Respondent?
Madam Arbitrator, the claimant's request to redact all business information is clearly inconsistent with the spirit of the transparency rules. Under Article 14a, the tribunal's discretion shall take into account the public interest in transparency. Clearly, our previous discussion has demonstrated that there is a substantial public interest in transparency in these proceedings, and blanket redaction is just inappropriate.
Thank you. I shall review the documents and determine what information should stay confidential and what should be available to the public. You may submit your briefs within 30 days. I want now to move to the last issue. Last but not least, I would like to know what the parties' positions are in regard to make this hearing public. Claimant, I would like to hear a point first.
I'll make it short, Madam Arbitrator. As underlined in our request of arbitration, Article 6 of the Transparency Rules states that the tribunal shall make arrangements to hold in private the parts of the hearing requiring protection. The Transparency Rules clearly provide a mandate to the tribunal to protect disputing parties' interests in a fair and efficient resolution. The cost and delays inherent to public hearings clearly undermine the integrity of the process. I think we can all agree on the fact that justice delayed is justice denied. Moreover, this will necessarily politicize the award.
Thank you, Counsel. Respondent?
Madam Arbitrator, my esteemed colleague just stated Article 6 of the Transparency Rules, but Article 6 sets out that hearings for the presentation of evidence or for the oral argument shall be public. Contrary to claimant's argument, confidentiality is merely a contingent exception. In light of the public interest in these proceedings, claimant's request to make part of this procedure confidential is inappropriate under Article 14A of the Transparency Rules. Therefore, we request that all hearings be made public.
Thank you. Let me return to claimant for a moment. Counsel, could you please explain what do you mean by politicizing the award?
Of course, this sort of political entanglement has become a real challenge for the efficient practice of investor-state dispute settlement. There is even growing concern over whether ISDS provisions will be included in the Transatlantic Trade and Investment Partnership, the so-called TTIP. This groundbreaking trade agreement is recognized as a pattern for future investor-state instruments. But such trade benefits are protected through ISDS provisions only if the parties know what they are agreeing to in concluding such treaties. No party should be allowed to take a private dispute and turn it into a public debate. Madam Arbitrator, at the end of the day, this is a private dispute.
Madam Arbitrator, this may be a private dispute, but it has public interest at its heart.
Thank you both counsels. I'm looking forward to receiving your briefs within the discussed timeline. Rest assured that I will carefully consider all your arguments. We shall resume our next discussion scheduled for 12 January 2015. Thank you.
At this time, I would like to invite tonight's panelists to join us around the table in preparation for our first panel on the UNCITRAL Transparency Rules. We begin tonight with our moderator, Professor Mirwat, who is Professor of International Law and co-director of the Global Governance Studies program at the Sciences Po Law School, seated at the center of the table. On the audience's right, we have Professor Rogers, who is Professor of Ethics, Regulation, and the Rule of Law, and co-director of the Institute for Ethics and Regulation at Queen Mary University of London, as well as Professor of Law at Penn State Law. Next, we invite Professor Fernández Arroyo, who is also Professor of International Law and co-director of the Global Governance Studies program at the Sciences Po Law School. Moving toward the center, we have Michael Polkinghorn, partner and head of international arbitration right here at White & Case Paris. On the audience's left, we welcome David Gaukrodger, senior legal advisor for the OECD Investment Division, just right here. Next, we welcome Eliana Maria Tornesi, who is counsel at the ICC Court of Arbitration. And finally, representing UNCITRAL this evening, James Castello joins us as a partner from King & Spalding, Paris. Professor Mirwat, if you would like to begin the first panel.
Thank you very much. The idea is that there is a list of collected questions from the audience and beyond. Each panelist will have 2 minutes, no more, to make a statement, after which we will go through the list of questions, perhaps throwing out to the panel, and perhaps no more than 3-4 minutes of response from each. We'll use up the time progressively. Thank you. So, perhaps we could start with Catherine.
So this is an additional 2 minutes after my 20.
Finish your speech?
Okay, yes, exactly. Okay, so I think that I would probably underscore some things that I said, which is that on issues that are as complex as this, labels don't help. They don't answer the question. So just saying transparency doesn't answer what we need and how to implement it. And calling something public, as we just heard from the students, doesn't necessarily make it so, at least in the minds of everyone who's listening. And so what I would encourage us to be sharp and clear in our definitions, to work at defining what our actual goals are, and then practical ways to implement them, recognizing this is a very dynamic field, both on the investment side and its intersections with the commercial side. Is that less than 2 minutes?
That's wonderful. Thank you. Diego.
Thank you. On this point of UNCITRAL transparency rules, this first panel, the first thing I think is the transparency rules are an answer to worries of states, NGOs, academics, and I think the United Nations have given a good answer, a good instrument to deal with those worries. The application will be maybe another thing. But the second point is that transparency is already the general rule in investment arbitration. That is to say, we cannot expect a revolution for these rules because really transparency is already here, at least in some way. And a third point, if I have time in my 2 minutes, is that I think the innovation of these transparency rules and other new rules that have been adopted recently by other instruments is that now transparency rules, in my opinion, have become the rule, the general rule. So that implies that the exceptions, and I found very interesting the debate between students, the exceptions should be constructed narrowly. That is maybe the innovation of the new generation of transparency rules.
Michael?
Yes. Does anyone know James Crawford? No.
Did he teach?
Yes, he told you. Yes. It's on his website. 1 minute left. I think that if you're going to fight this whole notion of transparency, you risk really looking like an old man shouting at trains. It's a bit late. If you look at the trends over the last 10 years, I mean, I think there are a couple of reflections. One is the premise that commercial arbitration is confidential. Well, not necessarily. The ICC's been battling with this for years as to whether ICC arbitration is confidential or not, and the new rules they try to tackle with that. You look at Bankers Trust, the decision out of the UK. You look at the Swedish decisions, the Australian decisions. It's not necessarily the case. It's a false point of departure. And then when one looks at transparency, you have to realize it's not just what we're doing here. Freedom of information bills and acts have been used as a way in the United States to get information, to get awards and what have you. It really is too late, I think. I think the gates are open now, and it's really just a question, as I think Catherine put it well, of how do we apply this now? How do we make it work in a way that there won't be a reaction against it? Because there's often this swinging pendulum that prompts negative reactions because people misunderstand the problem and its application.
Thank you. James?
Thank you. Well, I'm not really a representative of UNCITRAL in the sense that I don't work for UNCITRAL, but I'm here, at least in this part of the program, to sort of be an advocate for what UNCITRAL has accomplished. So I build on what Professor Arroyo has already said. I would differ with Diego just a little bit because I'm not sure how much transparency really is already the norm in investor-state arbitration. And I would say that these rules really go much further certainly than the ICSID rules on transparency, and they even go further than the NAFTA Chapter 11 practice on transparency. They guarantee access by the public to all documents that are submitted by the parties except for exhibits, and that is somewhat discretionary by the tribunal, and all decisions and orders and awards by the tribunal. They guarantee open hearings, and they guarantee a possibility of amicus filing. So I would say that really goes quite far. Now, the real test is one that Diego touched on and which is highlighted by the mock scenario, which we've just seen, which is that under the rules, and if people want to discuss this, we could go into it as to why that happened, but under the rules, they only apply automatically to UNCITRAL rules arbitrations under BIT treaties which come into effect after March 31st of this year. So the question is, how will it happen for the 3,000 BITs that already exist, where we know most of the arbitrations will be? And that is going to be a question of the will of the governments to endorse it. There are mechanisms in place for them to do that, including a convention, which has just been adopted by UNCITRAL, in which countries can sign. And it will be up to the investors to be able to agree often if the two countries have themselves not agreed. And that is really where the good test is going to be in the coming years. And I think that the TTIP debate may be a force to accelerate that interest of governments in doing that, but we'll see.
Thank you very much. Actually, in my 2 minutes, I wanted to cover some aspects, but now all these comments trigger me some more interesting thought. I'll try to stick to my 2 minutes. I should say that, first of all, I found these rules quite ambitious in the sense that they covered both issues that Catherine first assessed, which is the transparency issue as the accessibility to other relevant parties, and also the fact that some information are publicly available, public access to documents and statement and brief. I think that indeed investment arbitration has always been publicly accessible to all users, especially ICSID and investment arbitration. But I still think that there is a big portion of ad hoc arbitration, investment arbitration, which remain really silent for all the users. I nevertheless think that it's an important step. I think in the investment, at the stage especially of the investment arbitration where we are. And I think that some rules on transparency will help also the users to understand everyone's need. I found the conversation and the mock case very interesting. I should say that from my personal experience in private practice, I have more acted for private companies than for state, and actually it was the private companies that was claiming for public access, as in my case at least, just to show to the public community how states were handling their investment. So that was also interesting to see how other people would view from another perspective transparency.
Good evening, everyone. I think, well, when I went to Sciences Po some years ago, we used to be given 10 minutes, but I see that the brighter, younger kids can now do it in 2, and so we have a bit of a test thrown to us. But on the OECD, let me make a couple of points. First, the OECD, I think, played a key role in promoting and supporting greater transparency. In 2005, the Investment Committee put out a joint statement in support of transparency, and that was not coincidentally just before the ICSID amendments in 2006. And then in 2011, the Freedom of Investment Roundtable, which is a broader body that gathers not just OECD, but also Argentina, Brazil, China, South Africa, Indonesia, India, many of the largest players, put out a communication calling for greater transparency. Second, I think the evolution over the last few years, particularly among European countries, has been remarkable. If you look at the early submissions to UNCITRAL by some of the major European countries, and you look at the current position of the Commission, there is a huge change. So I think that's remarkable. If we look today, Going forward, some big players are now clearly on board going forward. So I think within the context of TTIP, I don't think transparency will be a major issue. But many of them have many existing treaties. So there, the UNCITRAL Convention will be critically important. The Secretary General of the OECD, Angel Gurria, put forward proposals to reform and strengthen investment treaties last month. I've put some copies in the back. The Secretary General considers that following the truly remarkable work at UNCITRAL in developing a framework for transparency, both going backwards and going forwards, it's time to achieve transparent dispute settlement in practice. I just note as a final comment, it's interesting that in the group here there are diverging views about whether there is currently a high degree of transparency and what it in fact entails. And I think the point that it covers submissions, which is I think something that is perhaps peculiarly North American in allowing access, is very important. And for other countries that will be a change. The public good aspect, just to pick up on public goods, I think for students and those of us who read these cases, the ability of arbitrators to refer to the record means that they won't have to repeat the arguments for 55 pages before you get into the case, and I think it'll provide for tighter, better written awards that can grapple with the issues, hopefully, more directly.
Thank you very much indeed. Now we have the challenge of the time frame, a long list of questions and some very interesting points that have already addressed, some of them actually including the novelty issue, which was one of the questions asked by a White and Case attorney who wishes to remain anonymous. Perhaps you could have that in mind in answering the following questions. Perhaps we could start with Eliana, picking up on something you've just said. Do you think that greater transparency rules, and of course, given this question of whether there is real novelty or not, do you think that UNCITRAL transparency rules would impact on parties' willingness to resort to arbitration? You talked about the access question. Is that going to create greater willingness?
No, it's weird. I'm not actually persuaded by this statement, I must say. I think that the transparency issue was already in the awareness of the users. I think that there is some clarity in the rules, and I don't necessarily think that there will be a big impact on the users as to whether they would go to arbitration or not. I think that arbitration in investment arbitration, especially investment disputes, is a very efficient tool which goes beyond what the transparency rules, the UNCITRAL rules are saying. So I think that it would be useful for the way investment arbitration is evolving, but I don't necessarily think that this will have an impact on the will of the parties to use or not. There's still some means on the way to exclude those rules. So I really think that it will not have a big impact.
Thank you. A second question raised by a Sciences Po student who also wishes to remain anonymous.
What happened to transparency?
This is the question to which we will come back. This question is for Diego Arroyo. And the question is, do you think that greater public availability of arbitral awards will help develop a settled case law and improve the quality of arbitral process? And it is I who have attributed this question in my discretion, and that's not part of the list of questions.
Okay. Well, I hope so. In principle, I think we can expect that the availability of not only arbitral awards, but also arbitral proceedings and some kind of exhibit and the access to open hearings may help to have several of the things Catherine mentioned in his opening speech, that is to say an improvement of the decision-making process, and may be an improvement in practice for counsels and also from arbitrators. That is theoretically, at least, the possibility. Reality not always go hand in hand with this kind of possibility or what kind of desiderata. And the reality is, from now, not as a member of the working group who elaborated these transparency rules, but as a practitioner, I think it's quite difficult in the reality to help to improve really arbitration. It's a long way, and at the end of the road, I think we can be optimistic, at least moderate optimistic.
Thank you, Catherine. Yes. This is also a question posed by an anonymous law student who asks whether you think that the transparency of arbitration proceedings can provide an adequate monitoring mechanism for the conduct of proceedings.
So I think that's a really important question, in part because it raises who is the public, to some extent, that we want to be monitoring this. And in certain contexts, the public is probably more limited to the state that's at interest. In some arbitrations where there are issues that transcend, I mean, you think about the tobacco cases, the tobacco case in Uruguay, where people in Australia are watching it very closely, or the milk case in Australia, where the New Zealanders are watching very closely. So the public is not going to always be limited to the state, but in some instances it might. And to what extent is there monitoring? I think we're seeing, I guess, in the promulgation of the transparency rules, which are a response, I would say, to people trying to monitor, being frustrated that there aren't avenues to be able to monitor effectively, putting pressure on various groups to implement rules to allow that. And I think as we see, in a sense, outcomes from this transparency, awards being published or decisions being made, we'll see more specific, targeted lobbying for, still further reforms through organizations like the OECD, perhaps in organizations like ICC, which is monitoring or administering more of these arbitrations. So I think it can. So do I think that increased transparency, was the question, will increase the monitoring? Yes, I think that's the adequately. Adequacy then is a really tough thing to suggest at this point, because I think it's a very fluid process. And I also think a lot of this, the expectations about transparency 5 years ago could not have been expected. What the baseline of expectations are now. So I'm not going to attempt to predict adequate, because I think just within a few years, what we consider adequate might be very different than what we're sitting here talking about today. But do I think it's an important mechanism? Yes. And do I think UNCITRAL did an amazing job in moving the debate forward? And setting out specific provisions that can help us even move it forward still, yes. But it's an evolving process, and even on the question of what constitutes adequate, I would say.
I think that something that we should not underestimate is also the fact that when arbitrators, when a panel knows that its procedural orders or its awards will be read not only by the party, I think that this will have a big impact when the panel will draft the award. I think it will be more cautious and more careful in the drafting. So I think that the monitoring maybe will be done by itself rather than by the parties. Rather than by the intervention of the parties. I think that we should not underestimate that element.
Thank you. Precisely, and this is an attorney question for Michael before we come back to the UNCITRAL rules. Do you think that the UNCITRAL transparency rules will lead to protracted legal debate over interpretation of some of the provisions?
Obviously not. It's like fair and equitable treatment, perfectly clear term.
Quite clear.
Why on earth would there be any debate about that? It's inevitable. It's inevitable. We saw it, I thought, with that excellent moot presentation earlier. You could see it coming, where you're going to have, and it will become a case where you will have two lawyers looking at the same words and arguing contrary positions, not necessarily different ones. It's just in the nature of the beast. It will happen. Will transparency therefore give rise to some sort of precedential value as decisions come out which will narrow or avoid the debate as time goes on? Not necessarily. I mean, if you look at the way lawyers these days are tackling res judicata, they're saying, well, yes, it's res judicata, but they were wrong, so here's what I think. No, I think it will definitely give rise to a number of disputes. You just hope that you'll have tribunals that will be able to keep that down to a dull roar and move on with the case itself.
Thank you. Yes, please go ahead.
Just a couple of thoughts. I think in any regime, I think the first decisions are going to be very important to see how they come down, and I think particularly this one. And the reason is because I think we saw the citation in the student's argument to the provision that says, in exercising their discretion, the arbitrators are supposed to take into account the public interest in transparency. I'm not sure I have the language exactly right, but that's broadly it, right? That's an interest that is outside of the tribunal room. And the entire culture of commercial arbitration, certainly, but I think also largely investment, has been inside the room. It's been, consent of the parties, very, very attentive to what the parties in the case want. That's one of the strengths, I think, of commercial arbitration. But here we have a new regime that says, you have to think about something else. And how much and how, those questions I think are going to be posed in the early cases, and one hopes that they will be well briefed and provide a transparent and thorough consideration of what the new role of the arbitrators is under this regime, because the parties, capital P and UNCITRAL, have put a lot of confidence and faith in the arbitrators' ability to manage this new regime.
Thank you, David. I was just about to ask you that question, so that's great. You've given the response already. Thank you, James, for the last 2 minutes of debate.
Okay, well, just to follow up on what David said, I don't want this to be lost, because if you actually look at the clause that we've all been discussing just now, which is Article 1.4 of the rules, it says that the tribunal, in making these decisions, is supposed to consult two things, and one of them is the one that David just recited and which was highlighted in the mock scenario, the public interest, but the second one is the disputing parties' interest in a fair and efficient resolution of their dispute. So we're back to Catherine's public versus private concerns, and obviously you have to think about both. Now, I think one thing that is highlighted by the question which was posed is that to Michael, is that there will be a cost. There's no question that there is a cost in terms of the speed with which an investment arbitration will be conducted in having transparency. The minute you start talking about having a debate about what is confidential, what is business information, and so forth, you will have a cost. The judgment is that the public value in knowing what's going on outweighs that. And I think that's a judgment that's been made by all of the countries at UNCITRAL that adopted these rules. But we should be aware of that when we think about each of the constituent parts. Disclosure of documents, whether or not an amicus should be let in, a particular amicus. This is a careful balancing act. How much will it actually assist the adjudication versus how much is it an outside group which simply wants to, be validated as being part of the debate, but may not actually bring that much to the debate. I mean, these are going to be tough issues which will come up in each case, and the rules are designed to allow the tribunal to deal with that by highlighting both considerations.
Wonderful, thank you very much. Now the program now provides for 10 minutes of Q&A with the audience. So this is going to be the opportunity for the various attorney practitioners or students or those who are both to ask questions. It's a unique opportunity to have such a prestigious panel assembled. So please go ahead. And if nobody asks a question, I've got a whole list in wait.
Good evening, my name is Anne-Charlotte Martin-Claire. I'm a trainee for GIT. So according to the rules, you have the treaties will supplement the rules, and I wanted to know if you see any difficulties in that implementation, whether the states will have to enforce their treaties. Do you see any difficulties why the UNCITRAL will not be able to promote their own rules? So the basic question is that when I read the rules earlier, I saw that the treaties that bind each states, will have to be enforced whether when the UNCITRAL rules will be in contradiction with this treaty. And I wanted to know if you, as an important, I would say, arbitrators or lawyers in that field, if you see any difficulties in these contradictions.
Contradiction between the UNCITRAL rules and the applicable treaty text, right? What happens then? This is the timing issue. She's talking about the timing issue.
I think
do you want to point to what you're talking about?
Yes, it is Article 1.7.
I don't know. This is the question for you.
Well, if someone else wants to answer it, I don't mean to hog the floor.
Does anybody see a difficulty here? No.
I think if I understood the question, I'm not sure. It's just the interpretation of Article 1, Paragraph 7. Mm-hmm. The idea is, at least the discussion within the framework of the working group, was because in some cases, states could have treaties in force which provide for more transparency than the UNCITRAL rules. So those states made a point to try to preserve the application of those higher standards. And I think even if the drafting of this Article 1, Paragraph 7 is not maybe the best one in the rules, the idea behind is the rationale behind it is to allow in those cases to go to the higher standard of transparency, which could be not in the rules, but outside the rules. For example, in a BIT or in CAFTA treaty or something.
Just to elaborate on what Professor Arroyo said, there are some countries, and my own country is one of them. If you look at the 2004 US model BIT, that has all of the provisions that you find in the UNCITRAL transparency rules, and I think the US State Department would argue even a little bit more. And they were very intent that they not be brought down a notch if their own treaty applied. But I think implicit in your question is, if I understood it correctly, is could a country then have a treaty which actually derogated from these rules, and what would be the effect then? And I think the sense is that a country, if it wants to exempt itself from the rules, it will in a future treaty. It will do so, and so it's really less of a risk to have a slight derogation by having a conflict in the treaty. If they don't want it, they'll simply say they don't want it in the treaty. So I think that's less of a concern.
Okay. Other questions? Yes, this one in the front.
Good evening. My name is Dmitry Bayandin. I'm Sciences Po Law School master student. My question also doesn't have a particular addressee, so it's a general appeal to all of you. Do you think that all this trend towards transparency in investment treaty arbitration could entail the same discussion in commercial arbitration involving state-owned companies? Thank you.
Who would like to answer that? Catherine?
I'll take a first crack at it, which is I do think that we're seeing already some pressures in the commercial side. There's a sort of semi-permeable membrane between them, in part because the parties go back and forth. So we're seeing already increased, not even, I would say, necessarily limited to state-owned entities, but we're seeing increasing calls for publication of awards, in not only just for the general public, but also so that parties in international arbitration can understand better what's happening in international arbitration when they resort to it. My particular point of entry or on this is arbitrators, and that awards, seeing what awards arbitrators have rendered can help us understand when we're selecting arbitrators what our preferences, how they might play out in particular awards. So I think we're already seeing increased expectations on the so-called commercial side as a result of transparency push in the investment side. I don't think it's going to necessarily go as far. But I also think the other places where you're seeing some of this is with respect to movement in other areas in commercial. So, for example, when you have non-signatories who are becoming members, and you're seeing consolidation when you have multiple parties, it's not quite the same as transparency, but you're seeing the idea of the hermetically sealed, bilateral arbitration being broken down on the commercial side, and it brings with it, I think, at least borrows some of these ideas, not quite to the same effect. And I wouldn't say it's limited to state-owned entities. I'll just add one other point, which is one question that I think has been raised is whether these transparency reforms are going to drive parties away from investment arbitration. Certainly, when I was suggesting earlier that you can have multiple options where a state-owned entity's contract can either give rise to a BIT claim or a so-called commercial claim. You might see some interplay there, even including with parties trying to opt out, for example, of the UNCITRAL transparency rules by perhaps going to one or pushing for the other. So I think you'll see them continuing to interact, particularly in those contexts where one claim can give rise to the two different types of procedural forum.
I think another slightly more pernicious way in which this may manifest itself is already being seen from time to time with practicing lawyers where, as usual, of course, we win our cases. And the client just publishes it. Bang, there it is on the website. And the other side can scream and shout, but the cat's out of the bag. What precisely would be the type of remedy they could seek? Probably not much. And I think that as people's attitudes towards arbitration change, they're no longer this holy grail or what have you that you can't touch it, you have to keep it the way it is, and people realize that it's not as confidential as you think. And I think some of these transparency rules may remind people of that. I think you're going to find a lot more self-help, which in and of itself I think will lead slowly to a greater sort of publication of awards generally.
Thank you very much for the question, Dimitri. I think it addressed the main point. In my opinion, even if the transparency rules are not applicable or are not deemed to be applicable in a commercial arbitration, at least not directly, really the leitmotif, the reason to have transparency rule is the presence of public interest. And public interest is involved in the same or in a similar manner in commercial arbitration or in investment arbitration since the moment when a state or a state-owned company is involved. So I think, at least in an indirect way, transparency rules and transparency standards will have an impact even on commercial arbitration. And in some sense, it's already the case. It's already the case.
Just one last quick thing, which is we're talking about transparency at an international level when in fact there's a great deal of divergence at a national level. So one of the things with my project that I found out is how many courts in the world, including sophisticated common law democracies, do not allow public access to court files, which is interesting to me. There are also a number of countries that when they publish the cases, they anonymize the names of the courts, including Supreme Courts of these countries, will have X versus Y when they publish the decision. To an American, where we have a constitutional right of access to all the court files unless they're specifically protected, that's really quite shocking. And again, there are a number of states in the world. So it's very interesting to me that we have in this room a certain baseline of understanding of what should be expected with transparency when there are radically different views within national court systems that are supposedly public, quite public.
Just very quickly, I wanted to express a somewhat different view from Professor Arroyo's, because I think that we have the tendency, all of us, to think, well, there's a state entity involved, as Professor Arroyo said, and therefore that makes it very similar to investment state case. But just to comment from the perspective of how it was that UNCITRAL got involved in this, I think there is a difference, because I think the perception was among the governments participating in UNCITRAL that when you have a public policy of a government that is challenged as violating fair and equitable treatment, or constituting an expropriation, or violating a ban on discriminatory treatment, that you really have a public interest that is implicated that is quite distinct. Whereas sometimes a state-owned entity really operates as a commercial entity. I mean, that is not unheard of. And so, to paraphrase what was a rebuttal to Freud, sometimes a cigar is just a cigar. I mean, sometimes a road project really is just a road project, and it happens to be a state-owned entity that has commissioned the road project. But I think the level of public attendance at a public hearing over whether the asphalt specification by the government was appropriate would be pretty reduced. So I don't think that it will happen just automatically, this segue from having transparency applied to investor state cases to all cases where you simply have a state-owned entity as one of the parties. That would be mine.
I can see the opposition. I can't see the opposition. I think we said more or less the same.
Okay. Thank you. I see the card for 2 minutes has just gone up. So I assume that is the end of the Q&A for the moment. We have that is okay. Because otherwise we could perhaps make the transition to the next panel, given that we also have a Q&A session afterwards. We could perhaps, the questions obviously merge.
Okay, we now move to the second of this evening's topics, which is the Transatlantic Trade and Investment Partnership and the future of the public-private divide in international arbitration. Immanuel Kant reportedly once said, "Seek not the favor of the multitude. It is seldom got by honest and lawful means, but seek the testimony of the few. And number not the voices, but weigh them." Ladies and gentlemen, the Sciences Po Human Rights Clinic introduces this second panel discussion by bringing you just a few voices of the TTIP.
In June 2013, the governments of the EU member states unanimously instructed the European Commission to start negotiating a free trade agreement with the US. They also gave the Commission guidelines setting out what the negotiation should include. In the guidelines they gave to the Commission, the government stated that the EU should seek to include provisions on investment protection and investor-to-state dispute settlement in the proposed agreement. Negotiations for an agreement, the Transatlantic Trade and Investment Partnership, started in July 2013. The European Commission is consulting the public in the EU on a possible approach to the investment protection and an ISDS in the TTIP. The key issue on which we are consulting is whether the US proposed approach to TTIP achieved the right balance between protecting investors and safeguarding the EU's right and ability to regulate in the public interest. EU Directorate General for Trade, online public consultation, July 2014.
TTIP's biggest threat to society is its inherent assault on democracy. One of the main aims of TTIP is the introduction of investor-state dispute settlements, which allow companies to sue governments if those governments' policies cause a loss of profit. In effect, it means unelected transnational corporations can dictate the policies of democratically elected governments. Lee Williams, The Independent, October 2014.
Since 1975, the United Kingdom has signed over 19 bilateral investment treaties, the majority of which include ISDS provisions. These agreements have not undermined the UK's ability to regulate in the public interest. To date, there has not been a single successful case brought against the UK under these treaties. UK government response to the House of Lords, European Union Committee's 14th report, July 2014.
If the US and the EU can't come to a trade agreement, including ISDS, even given their relative cultural and economic harmonization, then what hope do they have of persuading China to agree on it in any future trade deal negotiated with Beijing? Finbar Birmingham, International Business Times, October 2014.
The Council mandate is clear in its inclusion of investor protection mechanisms in the TTIP negotiations. We need to work together on how best to do so. Leaked letter from 14 ministers to EU Commissioner Designate for Trade, Cecilia Malmström, Financial Times, October 2014.
My Commission will not accept the jurisdiction of courts in the EU member states be limited by special regimes for investor-to-state disputes. The rule of law and the principle of equality before the law must also apply in this context. The negotiating mandate foresees a number of conditions that have to be respected by such a regime, as well as an assessment of its relationship with domestic courts. There is thus no obligation in this regard. The mandate leaves it open and serves as a guide. I had told my commitment on this point was very clear, but I am happy to clarify and reiterate it here today, as a number of you have asked me to do so. In the agreement that my Commission will eventually submit to this House for approval, there will be nothing that limits for the parties the access to national courts, or that will allow secret courts to have the final say in disputes between investors and states. EU Commission President Jean-Claude Juncker, speech to the EU Parliament on the day of the election of the new Commission, October 2014. All of these voices lead us to one question.
What is the future of the public-private divide?
And what does it mean for the practice of international arbitration?
Thank you very much again. I think we're going to repeat the exercise that we went through earlier, so we have a round table again with 2 minutes and no more for each participant, and we will be symmetrical. And so I'll start with David. Have you got 2 minutes of reaction to this TTIP debate?
Thank you. I think the existence of this intense controversy, I think, is overall healthy in sort of strengthening the scrutiny and debate about the system. I think it also puts a strong premium on efforts to educate the public, both about the system, but also for proponents of the system, including governments, to make the case. And I think there's still more to be done, as I think the House of Lords report on TTIP concluded, that governments have not yet succeeded in making a fully convincing case. We note this kind of evolution because we had the pleasure of having Catherine speak at our group at the Freedom of Investment Roundtable a couple of years ago, and then we had a public consultation, and ours generated 45 comments, I think, roughly, under 50, I think. They were very interesting, a wide spectrum of views. But I think when we look at the results of the EU consultation, we can see the incredible evolution of the debate in a very, very short period of time. I think there is a greater public interest, I think, in many investment arbitration cases than in many commercial cases. Governments have largely borrowed the private commercial arbitration system. I think that borrowing is coming under increasing scrutiny. In his October blog, the Secretary General of the OECD emphasized that it is important to boost public confidence in investment arbitration. And in particular, he noted that advanced domestic systems go to great lengths to avoid the appearance of economic interests affecting the resolution of disputes between investors and governments. And he stated that it is time for investment arbitration to do the same thing. Thanks.
Thank you. Eliana?
Well, I think that the system which the arbitration at least system is a useful one for it has been a useful one for the consolidation, I would say, of the international environment and the development of the certainty of foreign investor in national states. Having said that, I think that we are actually seeing a multiplication of fora on where to go to have its rights being heard. So I think that as a general principle, it's still important to keep the international and investment dispute separated from national courts. But maybe a multiplication or a development of a further system to the one already in place, like the WTO dispute settlement or the ICSID settlement dispute, maybe might be wrong. So that is my my thought, I think, on the topic.
Thank you. Well, I need to make clear at the beginning that in this part, I'm not speaking on behalf of UNCITRAL, because UNCITRAL doesn't have a position on TTIP. And I'm also not speaking on behalf of the US government, which I've had the privilege of representing for several years at UNCITRAL, but really as a private sector practitioner who's represented both states and private companies in arbitration. And I would use this debate, and here I think I would differ with David. I have found the debate over TTIP so far extremely disappointing, and it's been disappointing because there are so many untruthful and inaccurate statements which have been made, and I think a lot of it is made out of just sheer ignorance of how arbitration is conducted, and that leads me to the conclusion that it is a demonstration of why more than ever some frame of transparency for investor-state arbitration would be beneficial, because I think that it would show people really what the process is about and remove a lot of the suspicions and the mystery. You read repeatedly in both editorials, letters to the editor, and also straight news articles that this is a secret system of justice, and it's always said with a sort of a sinister implication that something untoward is going on here. And I think people would actually be quite surprised if they saw the level at which most international investment arbitrations are conducted. Similarly, I've seen it said repeatedly that this is something conducted by corporate lawyers, which is always a terrible term. Corporate lawyers are terrible people. That is conducted by corporate lawyers just to further their own interests. Well, okay, the most recent investor-state arbitration that I concluded as a counsel to a party, the three members of the tribunal, two of them had worked for corporate law firms for many, many years, but one of them was a former minister of justice of a G8 country, and another was a former senior legal official in the foreign ministry of a G8 country, and the third was a professor of international law for many, many years. So I think, you know, if you compare that to judges, and I'll use my own country as a frame of reference, the United States. If you went and took, and I have great respect for the quality of the federal judges in the United States, not necessarily all state judges, if you took them and asked, and just did a survey, how much do they know about public international law, I think you would be shocked. And I think the conclusion that has been drawn in many of the statements in Europe about it would be much better off you're avoiding the high quality of justice in the courts, it needs to be re-examined.
Yeah, I think the debate, I think it's a good thing there is a debate. I do agree that it's been a bit disappointing on both sides. I think there's a tendency to get sanctimonious about these things from time to time. But my point is more a sort of despairing reflection as well, that while this worthy debate is going on, much of the business community is not really paying much attention. You know, let's not kid ourselves. I remember when I was asked to comment on the fact that Australia in a treaty with an Asian country was looking at having no dispute resolution provisions whatsoever. And my comment was, well, so what? Our businessman will therefore set up, or should chart his investment through a country that has one. I'm putting aside some of the European BIT debate, but the business will basically, as these issues come up and as we're confronted with them, in the same way as we can look at some of the tax avoidance schemes, the sad thing is people will work around these things. So it's a worthy debate to have, but it's nowhere near the end of the discussion that will have still to take place concerning the whole issue of investor-state arbitration when dealing with Europe or elsewhere.
Thank you. In my opinion, this debate about the transatlantic partnership is a very good opportunity to debate about, in general, to international trade, to north-north trade, and also to investment. But the first point I would like to remark is that the partnership is much more than its chapter on dispute settlement. Even if all the discussion seems to be around the investment arbitration, there are many other things, and maybe much more important in the discussion, in the negotiations, than investment arbitration. The second point is, in my opinion, that there is an impression given by some politicians and even some scholars that these negotiations are creating investment arbitration. Of course, it's not the case, and maybe is the contrary. Is a good opportunity to debate about the improvement of investment arbitration and to increase transparency, to put more certainty, etc., etc., and more accountability of arbitrators. For example, there are many things that we can do with these negotiations. Of course, there is other possibility. Another possibility is to avoid investment arbitration, to say, well, not investment arbitration is allowed in the framework of this treaty, but we need to be aware that if we decide to avoid investment arbitration, if it is possible, I don't know, in any case, for example, in France or French corporations will continue to introduce proceedings against African states or Latin American states using the 80 treaty, bilateral treaties in force in France. That is to say, that is just a very little part of the reality of international dispute settlement.
Well, those are all very interesting comments, most of which I agree with. I do think that it's important to have the debate, although even if some of it has been hyperbole, devolved to hyperbole and ill-informed discussions. I will say one of my frustrations with the debate is that I think oftentimes procedures are targeted when in fact the dissatisfactions with substantive outcomes. So I think people, and they focus on the arbitrators because the arbitrators are the ones who produce the substantive outcomes. But for example, one small example where there's been a lot of criticism is, arbitral tribunals always interpret their own jurisdiction expansively. And so by interpreting expansively, what they do as corporate lawyers is they create more opportunities and income for themselves. And isn't that a sign, a sort of, self condemnation, right? Just a clear sign of how corrupt this entire practice is. Well, I would argue, you might disagree with the expanded jurisdiction as it's played out. And that might be something that is very worthy of curtailing expressly by the states, and they have the power to do that and perhaps should. But I would also say it's an inherent nature of adjudicators and adjudication. So in the United States, we have Marbury versus Madison. Talk about a huge power grab where the Supreme Court created for itself judicial review. Okay, you can't have a more aggressive expansion of jurisdiction than that. If you look at the European Court of Human Rights, it's also expanded its own jurisdiction, as has I think the WTO appellate panel. I think it's part of the nature of an adjudicatory process. And so to say it's only happening with investment arbitration, I think is an unfair critique. Does it mean we shouldn't respond to the outcomes we don't like, or states shouldn't respond to the outcomes they don't like? You know, absolutely. But let's keep separate the substantive outcomes from the procedure, and particularly certain substantive outcomes that we attribute as sort of malevolent or bad decision-making by arbitrators, when in fact it might be a fully plausible substantive outcome that you disagree with, and perhaps should lobby substantively to change or curtail.
Thank you very much. Now we'll repeat the previous exercise too. So I have a list of questions here collected from various constituencies who are in the room or out. And there again, we'll go around the table. Many of the questions actually touch on things that people have just said, or vice versa. So this time I'm going to start with David. And I'm going to ask a question that was formulated by an attorney, apparently a White and Case attorney. We'll say no more. About middle ground. In other words, do you think that more of a middle ground might be appropriate? In other words, the current debate is very much cleaved for and against, and I think there are very much two camps. So would another possibility, or perhaps a more reasonable possibility, be to retain the current system, but concentrate, for instance, on better drafting of the BITs, for instance, including transparency provisions? It's really a reflection on the current state of the debate, in fact.
Yes. This question, I had a little bit of difficulty with the idea of retaining the current system. I think already the European Commission has moved very far down the path towards NAFTA and beyond. So if the current system means, say, a member state, European member state traditional bit, I don't think that's in play at this point between the EU and the US. So I think we are talking about a fairly significant degree of reform. It may replicate what has been done already in the CETA agreement with Canada, and how far things will move from there, I think, is really perhaps more the question. I think certainly a middle ground is probably the right place. This is a very divisive debate. I think on both sides there are some arguments that are not very persuasive, but quite emotional. I think there's plenty of room for finding solutions in the middle and trying to reform the system to address public concerns, because there are some public concerns. Governments have recognized that there are valid public concerns. And I think in order to allow the system to thrive and continue to serve the purposes for which it was designed, we do very much have to look for a middle ground. But I would not suggest that at this stage would involve retaining the current system, because that, I think, is not where we're at.
Thank you. I'm going to deliberately ask James a question that one might have thought that I would put to Catherine, but I will not, to have a different slant on things, which is, do you think the TTIP negotiations might lead to the development of standardized ethical norms, which is an interesting concept? You'll have a go later.
Possibly. I guess the best way to address that is to say a little bit about the process which Professor Arroyo and I were discussing just beforehand, because he also was a member of the working group at UNCITRAL. There's a recently retired congressman in the United States who was a very witty guy and very quick on his feet. And once during a recent vote on the congressional pay raise, this is something we go through every year, where Congress is going to have an automatic pay raise, and then it's an occasion for members of the Congress to get up on the floor of the House and say, I don't want this money, I'm going to turn it back to the Treasury, I don't deserve this money. And finally, Representative Barney Frank got up and looked around the room and said, never have I seen so many members voting no and praying yes. And I think one could say a little bit about the debate on transparency. I think it is fair to say that there were a number of governments who were, and we have a tradition at UNCITRAL that we don't identify governments' positions, so I'm going to honor that. But there were a number of governments who had enormous reservations about transparency in investor-state arbitration. And it was a very hard-fought debate, and it is public. I mean, people can come and watch if you're an observer. And I think people who watched it would say that that was the case. And yet, nonetheless, at the end of the day, after 3 long years, we reached an agreement on a document, which I think is really quite good, but the most amazing thing is we reached this by consensus. UNCITRAL operates by consensus, and you have guaranteed by the design of UNCITRAL complete geographic distribution. So you have a fixed number of countries from every major geographic area in the world, and you have countries represented every single kind of economic system, every kind of legal system, and every stage of development. And so I think that tells you that if you put your mind to it and you really say this is important and we need to do this, that probably you can do it, but it's not easy. And Catherine knows exactly how hard it is and could say much better than I.
Would you like to?
So I'll say just a few words, which is my understanding actually is that that some countries were specifically identified the lack of ethical rules for counsel as a concern about investment arbitration. And I got this as an informal question from a couple different government officials, what rules apply, and and just the fact that they're asking what rules apply is itself sort of astounding, right? And this is also public, is that not an investor-state arbitration, but a state-to-state arbitration over the interpretation of an investment treaty, and this has been said publicly so I can say, but the US government actually approached me with this really gnarly ethics question that I could not have dreamed up for a law school exam. It was just insane. And when I explained to them the answer, they were, this is bizarre that that's how this would work out. So I think it is an issue. I also think one of the sort of public goods that is emerging is some more harmonized and standardized rules of what should govern the conduct of what I think is emerging an international bar. There are a number of lawyers, many of whom are probably in this room, who defy the traditional model, right? That you grew up in a particular legal system, you went through your lower education in that legal system, and so you have certain cultural values, and then you go and become part of the legal culture and legal profession in that system. There are many people in this room who I'm guessing have grown up in 3 or 4 different places, have legal educations in multiple places, including some of the organizers I know. And the idea that they are somehow a lawyer of the United States or a lawyer of Paris, I think we're seeing an international bar develop. The place, as I said, the place we know it's developing is international arbitration, in particular also investment arbitration. And I think we need to see more clear rules. The IBA has developed rules, new guidelines for counsel. I think probably investment arbitration needs its own guidelines, its own approach. But as it has in other areas of practice, I think it'll stand on the shoulders of the work that's been done in commercial arbitration, because they've worked through some of the hard issues, not always with the answers we want or that might be appropriate for investment arbitration, but they've worked through or parsed through some of the difficult issues already. And also some of the institutions, because among the things, the hats James wears, I have to say, he was also involved in some new important innovations for the LCIA in enforceability of ethics rules for counsel.
Thank you very much. There's an interesting sociological point about the composition of the bar that we would you like to talk about that? Otherwise, I was going to, I'll do it later. I was going to ask Diego the question, which is a law student question about public policy. And the question is, do panelists, and particularly Diego Arroyo, see norms of transparency as becoming public policy and perhaps even mandatorily applicable in future cases?
The answer is yes. I think it is at least in a way, because otherwise afterwards James will say that he disagreed with me, but only to explain, because we have a short time to explain the things. But I think in a way, at least in understanding of the concept of public policy more narrow and not exactly the same we use normally in international settlement of disputes, I think yes. In particular, I insist in my first point, the transparency rules of UNCITRAL are based on the idea according to which there is a decision of the United Nations to support transparency. So transparency becomes the general rule. And the exceptions must be constructed in a narrow way. That means that in a very general approach that is a kind of mandatory rule on transparency, and you can afford only for some narrow exceptions to that principle. So in that, at least according to that approach, I think we can say that it is at least an emerging public policy principle.
Diego, I do not disagree.
I think this maybe addresses the conflict question that the young woman asked of the first question. Is this not the question you had in mind, perhaps?
It was not. It's interesting to
put them together. Okay, now perhaps I will come back to Catherine with a big question here about the OECD, which here again is a student question. In the light of the inclusion of arbitration in the OECD model conventions, how does the OECD recommend balancing the public and private interests in the future of international arbitration? It's a very big question.
So I think, first of all, I think David should be getting this question. but no, first of all, I think one of the things that's interesting actually at the international level is the role of non-governmental organizations that are working very closely with governments, or transnational government organizations. So some of the major entities that have been pushing on these issues are the OECD, UNCTAD, UNCITRAL, right? They sort of incorporate states, but are not sort of, they have the participation of states, but they're not of a particular state's view, and they're abstracted or separated from particular disputes. So I think in terms of structurally, who's in the best position to be able to strike the right balance, it is organizations like this that get the input from states but are not sort of deciding on an individual bit basis, for example. I think the work of the OECD, I can't say I'm entirely objective, having been invited to such an amazing event, but it really was quite prescient in laying out the questions. And I think David sort of already alluded to the fact that 5 years ago the answers seemed to be quite different. But it was originally the asking of the questions, I think, that was so important to setting the stage, to finding the right balance. And that's one of the things that the OECD does, and that other organizations transnational organizations are able to do. To help bridge, I think, the gap in the debate between what have been described as two very polarized sides in it. Mm-hmm. And so in that sense, yeah, the answer is yes.
Okay, this is interesting because it's it's a smoothing account, right, of a very, very contested field. I think I'll now go to a question for Michael. Which is a law student question, and it's about the risk that transparency generates in reducing the attractiveness of institutional arbitration. So it's perhaps the corresponding question that the one was asked earlier, which is, will arbitration, as Eliana said, will be more attractive to parties? And now we have, is there a kind of a cooling effect of transparency rules on institutional arbitration?
That's a really, really good question. I think one of the two answers. One is, better take this microphone. There we go. No. The two answers to the question, I think I'd slightly reformulate it in terms of whether it dampens one's enthusiasm for institutional arbitration for a sad but true fact, and that is, well, if you don't do arbitration, what do you do? And that's one of the problems you have, I think, in terms of the defence of institutional arbitration, insofar as there's nowhere else to go. And that is why I think we have seen some excesses in the way in which international arbitration has been practiced, and you have the horror stories of matters that I remember when I was on the ICC court, seeing costs overrunning and what have you. But I think coming to the point about, is this going to have a negative effect? I think in terms of perception it might. I mean, I've had cases in the energy field where the client has been incredibly keen to keep things confidential. And these are potential investment disputes where there was the possibility we could have gone contractual or investment arbitration. We didn't go to investment arbitration because states often perceived that as aggressive and they wanted to stick around. But the other point was, wait a minute, if this gets out, positions will become entrenched and there's no way we'll be able to settle this case. The case ultimately did settle. And why? Because we managed to keep it behind closed doors. I'm perfectly frank. There are arguments as to why perhaps the people of this country should have known about it. I don't know. But what I can tell you is if it had become public, the case would have earned me another couple of $1 million because it would have never settled. So I think there is an issue there, certainly amongst not the broader public necessarily, but the users. There's clearly a concern there. And whether one talks of confidentiality, privacy, transparency, it is a worry for some.
Eliana, does this contradict what you were saying earlier, or is it compatible?
I was actually referring more to investment arbitration rather than commercial arbitration. I think that indeed commercial arbitration, or at least institutional arbitration, have the privilege to manage to keep the proceedings confidential, and that is a very big, and that is an important feature for the users. So I think that's, I was referring to a different kind of proceedings, and maybe where the issue at stake are a bit different, I think. And for in this respect, I think that commercial arbitration should remain, or at least I think that it's better for those kind of disputes to remain confidential rather than being public, while investment arbitration should definitely be more transparent.
Thank you. I think this is certainly a question that we might be able to throw out later, but this distinction, I'm not quite sure that everybody would agree. Can I go back now to David about the needs of trade? So there's a needs of trade question here, asked by a White & Case attorney, who's still anonymous, who asked to what extent, if at all, is the TTIP an accurate reflection of the evolution of the needs of international trade? So this is the much broader context of the TTIP in general.
Yes, I should preface my remarks by saying that we work really more on the investment side than on the trade side. But I think the desire of governments on both sides of the Atlantic to work together and harmonize and work strongly to improve the interaction of the economies is a reflection of the increased connections that constitute trade in today's world, with global value chains that involve multiple movements of goods and services. For us, I think one interesting element of the trade aspect, that investment treaties are now typically negotiated in a trade context, is that the logic of trade negotiations is different than investment, I think, and or at least a lot of trade people look at it differently. Much of trade is about trying to create a level playing field, knocking out barriers, trying to foster the alignment of competition policy and trade policy is often underlined. Whereas trade people look at the investment scheme and they see a scheme that involves preferential rights, certainly preferential procedural rights, and in some cases preferential substantive law rights under some treaties and interpretations. And that kind of, I think the trade vision of that has been part of what has generated the debate in the last few years, because trade people are looking at this. And I think, for example, in the European Commission, they were given the competence in the Lisbon Treaty, and they brought in people who knew about trade to look at it. And they looked at it and they said, gee, this is interesting. How does this work? And so I think that element of the trade angle we have seen, and I think it is important that the two work together. But as I say, I close with the same admission of ignorance about trade that I opened with. So thanks.
Thank you very much. May I go back to the sociological question that Catherine raised, and this is not in the official list of questions, but as you brought it up, I was going to ask it. It seems to me that both this public interest for investment arbitration, the controversy that the TTIP negotiations gave rise to, is probably a sign of the times. It's a sign of the times of the need of reason giving in general. So I think that goes to the heart of your, the heart of ethics. But there may be a more sociological aspect, which is a kind of a peopleization of international arbitrators, perhaps commercial arbitrators, perhaps investment arbitrators. But don't you think that there's this phenomenon, the bar is changing too? It's a multicultural, cosmopolitan field. It probably always has been, but it's probably getting more so. And the arbitrators themselves are to a certain extent stars who write books and who appear in the public space. So do you think that this is changing in all your experience? Do you find that this is in some way a factor that weighs on the debate about being in the public space?
So let me see. First of all, lots of interesting ideas there. So let me see if I can unpack a few. One of the most important, I think, points to keep in mind as we're talking about this debate is it's happening in the context of a much larger shift, right? So if you look at IMF reports and various other reports about GDP, so in I think, citing statistics we recently heard at a conference, the amount of GDP that the West and Europe is responsible for today is going to shrink to less than half that size by 2050, with some of the biggest gains coming in Africa, for example. And that's already being previewed by, I think, the disputes that we're seeing in not only investment arbitration, but in commercial arbitration, and the rise of new arbitrators from these places, right? So as you see developing countries inviting in foreign corporations, which they have obviously for decades and even centuries, to exploit local natural resources, they enter into agreements, and those agreements give rise sometimes to disputes. More and more developing countries are insisting on arbitrators who look and sound like them, or who share a background, a legal culture. And interestingly enough, more and more of the people from those jurisdictions are getting law degrees from other jurisdictions. Our LLM program just at Penn State, and then again at Queen Mary, has 600, 700 per year just at those two schools, of people from foreign countries who want to get either a UK or a US law degree. They take the insights from that. That's part of, I think, where transparency norms are spreading from, because in jurisdictions where these are not part of their legal tradition locally, when people go to another place and study in a place where there is much greater not just tolerance for, but expectations about transparency, they bring those norms back. So I think, and is this happening with arbitrators? Yes, I think but it's also pushing the need for, I think, greater transparency with arbitrators. And I think also there's a sort of revenge of the outsiders coming, in the sense that it has been a very tight-knit, cloistered group that all know each other, and so those phone calls I was talking about happen among people who know each other. But when you get a new arbitrator from Peru or from Zimbabwe, it's harder to find someone among your in-group who knows someone about that. And so I think, yes, the socialization is expanding outward. It's part of what I think is creating pressures for increased transparency, and particularly expanding the group of arbitrators who may look at some of these issues in a different light.
And how about the public eye?
I take advantage of your question to stress on another point. Definitely the sociological component of arbitrators is changing, but transparency, which has or which can have many good consequences, has also a risk. And the risk was already identified by several observers, which is the increasing type of arbitrator that Emmanuel Gaillard has called the arbitrator narciso, no? the narcissism, arbitral narcissism. And maybe he was talking about him. But Hugo Draeta calls that the arbitrator prima donna. And then, of course, if you know that thousands of people will read your award and will be looking at what are you doing, of course you have the temptation to speak for the people and to pass to the posterity in the best possible way. So that is a risk of transparency. That is a clear risk of transparency.
David?
Just, because I'd be interested to hear thoughts on the new CEDA approach, which is, at least under the current design, is to put together a panel of 20 people nominated solely by the governments, and that would be the group from which a default president or chair would be chosen in the absence of party agreement. So that would quite dramatically change the calculus of the parties in making their nominations, because if you don't agree, you know you're going to go to this group of 20. And I don't know how they got to 20, but I'd be interested to see what the profession and academic community thinks about how that group can be formed, because I think there's a lot of work that needs to be done to determine, well, who those people are, but what are the rules? I mean, is it going to be almost like a court in terms of your incompatibilities outside, or are you going to be more like an arbitrator today? So I think the idea has been put in. I think it is quite a radical innovation, but I think there's still a lot of thinking by academics, students, and also the profession in terms of how it is going to be put in place, if it is going to be put in place, because some of these things remain kind of a dead letter, whether they can actually achieve it and how it will play out.
Thank you very much. I think this addresses the issue of what other alternatives are there. Or is there? Perhaps there's only one, I don't know. But this middle ground idea that's borrowing a little bit from various models that we already know is extremely interesting. Of course, one might say that one alternative is throwing a dice, but it's maybe cheaper and more consistent, but that obviously would be extremely cynical. Now we have 10 minutes to open the floor to Q&A. And perhaps some of the issues, whether the more technical, and when I say technical, maybe more economic, about trade, the ones about ethics or public policy, the ones about sociology, maybe they bring to the surface a certain number of ideas.
Good evening. My name is Calliope Sadborough, and I work at the ICC International Center for ADR. And this was a question I had during the first Q&A, and then I ran out of time. And Mr. Polkinghorn reminded me of the question when he said there is no alternative to arbitration. And of course, working in ICC's mediation cases, I was thinking about the IBA rules for investment mediation that have been published. And actually, my question was, with respect to the UNCITRAL rules for transparency, whether the pressure that increased public involvement would have in investment arbitration proceedings might trigger an increase in settlements, perhaps before filing or in the early course of arbitrations. If there are any thoughts on that from anyone, I'd be interested. Thank you.
Sounds like a very good question. Who would like to, Michael?
I should clarify one point. I'm a bit of a champion of mediation. When I was referring to no choice, it was as a final form of dispute resolution, because I think in the energy field, it's ripe for mediation because you have so many long-term contracts, continuing relationships, and what have you. In my experience, parties settle when, this is going to sound very trite, but I'll explain it, when they can and when they feel they can. And there is frequently a real problem in reaching settlements with states because states find it harder than private companies to settle cases. I mean, I have debates about this, but I'm convinced of that. And I've had a number of state clients and they've just said, we have nothing to measure this result against until we have an award, and then we can talk. So I think that you would have to really look and choose your public very carefully to know whether inconvenience, concerns, the fact this may take a long time, the risk of a really bad result, all of these factors, that will work for some parties but not for others. So I think it's very difficult to be more general to generalize in that situation.
Well, I just briefly would agree with what Michael has said from my own experience, and I think it is partly an answer to your question about whether you would see settlements at an early stage of a case because there will be increasing transparency about the case as it goes along. And my own answer, and I think this may be what Michael was saying, is it's almost a binary process. And the minute the case becomes public, then I think it's at that moment that it becomes certifiably more difficult for most governments to settle. And I myself have spent several years working in the United States government, and I would say even for a country where you have a long tradition of being able to say if you're really pressed that you made a mistake, it's hard. It is still hard, and so it's even more difficult in a country where you may not have such a robust representative form of government, and the particular government in power may even risk being challenged by the minority in parliament, and it may even, in an extreme case, produce the fall of a government if they have to admit that they've made a mistake. And often settlement is viewed as being tantamount to admitting that you made a mistake. So I think it is a very different situation than the situation between two commercial enterprises. And I think that's a cost probably of transparency. And I think that having gone into the transparency to debate, I think that was recognized as a cost, and it's accepted that that is a trade-off that we all have to live with for the benefit of having transparency.
Diego, you wanted to talk about this, and then David.
A very short comment that I agree in general with the previous opinions, but there are also many opposite examples, and I am thinking of, for example, some experiences with Argentina, which is not deemed to be the best part in investment arbitration, has not a very good reputation, but in several cases, in big cases, for example, the case of Repsol last year, although there were already a case before an arbitral tribunal, and it was a very public, very transparent proceedings, there were both parts need for an agreement, and parties agreed. That is to say, it's not impossible, and even if it was, I think, the most public affair in the recent history of Argentina.
We have a question here.
Yes, Jean-André Diaz, I'm with Total in Paris, and in fact, reacting to the last exchange about what are the other options, there is always another option. It's simply to go to the court, to the local court. So if you do nothing, this is the only opportunity you have. So going back also to the discussion about TTIP, should it be more public, more transparent, etc.? Probably, at least in my view, the question here is a discussion about arbitration or no arbitration. And I see that the questions and the criticism that were made were, of course, on the basis on some technical points, but in fact it was a political comment. It was a political comment saying we want it to be in the court, in the local court. So it is not a theoretical, is it better to have a little bit of transparency, a lot of transparency? It's more a political discussion now. And so this is going on since a few years, but now it's clearly on the table. So it is not, do we want to be more public in the arbitration, but do we want to keep an arbitration?
Well, this is the question, and I think maybe one or two of you have addressed the quality of the public debate, saying that you were disappointed by the public debate, which is precisely on this issue of democracy that's at the heart of investment arbitration. Would you like to address that, perhaps taking a step back and seeing what the options really are?
Well, I agree with you that there has been a very strong current in this debate saying we prefer the courts. I personally have felt that that debate has glossed over a few facts. One is that the debate has often presented the state or the quality of courts as being uniform within the European Union, and I think that most outsiders would say it isn't. I practiced for several years in Vienna, and I think most lawyers in Vienna would say that they would not counsel their clients as outside companies to go into the courts against the host government of most of the countries surrounding or in that region of Europe. Let's just put it that way. I think that is a very widely held view, and I think that if you look at the ratings of, say, Transparency International about the perceptions of corruption and so forth in many of those systems, that is somewhat borne out. I don't mean to make this all one-sided, so let me say in reverse, I have been very surprised after years and years of hearing European companies complain about having to face American courts, having to face American juries, having to face American discovery, having to face American lawyers, even American corporate lawyers. To hear people now suddenly say that they would be perfectly happy to have no investor-state arbitration option and instead go into court. So that's partly what I meant when I said I've been disappointed in the debate, because I think it's denying certain realities which for many years we've been hearing about, and I think we need to be more honest about the debate being a little more difficult than it's been presented.
Okay, does that answer your concern? Right. Are there any more questions on the TTIP? Right. Yes, sure.
Which I thought was an interesting insight about the 20 arbitrators to be appointed as chairs, and you posited sort of what will this change. So one thing I think is important to think about is the role of the chair and how it's distinct from the party-appointed arbitrator. And clearly that's what this is aimed at. One of the most important ways which I think that they are distinct is that, or one of the most important issues in which they should be distinct is issue conflict. So we hear recited all the time, arbitrators have the exact same, chairs and party appointed have the exact same ethical duties. Well, I've questioned that quite seriously because I think it's something we recite, but we don't take seriously in the procedures that we appoint arbitrators for. And the place where it's most borne out, I think, is with issue conflict. It's well known that there are certain arbitrators who are considered ringers for either side, either for the state side or for the investor side, and we count on the chairpersons to be the tiebreaker. And so you might almost have to take it as a foregone conclusion when you're talking about a group like this that issue conflicts, are an accepted part for party-appointed arbitrators. They're going to have written about these things or talked about these things or ruled in a previous arbitration on a particular issue. But we might be much more sensitive, for example, at least with regard to certain categories of issue conflicts for the chairpersons. I also think it's very interesting that when they've gone so far as to say we're going to have a panel of 20, that they haven't said it's the exclusive body from which a chairperson can be drawn, which is a really interesting place that they've stopped short of. And that it does start sounding a lot more like a court, but that they've said not all arbitrators have to be chosen from there, just the chairpersons, which I think is interesting and designates even further the special role that a chairperson has that so far I think has been largely lost in or overlooked in the debate.
Thank you. If there are no more questions from the floor, then maybe I'll take up, just as a word of conclusion, one of the questions that was asked by a student who says, in which ways would the TTIP represent a shift of paradigm with regard to investor-state arbitration? That's an interesting question. It obviously has a lot of theoretical dimensions, and I just want to make two types of remarks. First of all, one that's immediately connected to this discussion that's just been going on in several dimensions. I thought it was very rich, which is perhaps paradigms of democracy are changing. In other words, the democracy is at the center of this TTIP debate, as has very rightly been pointed out, because the choice that was opened was between arbitration as an institution that in some way restricted expression of public interests, and between the courts. The alternative is that. It may well be, and I'm not quite sure what the answer is, that these ways of working out transparency, James talked a lot about education, I think, perceptions, those are parts of changing ideas about democracy in which we have to fit this debate. The other change of paradigm is actually the transnational, the international legal order, and Eliana talked about the multiplication of fora as a given. I think that's extremely important. I think that there's a whole new paradigm of multiple fora and peer review. In other words, maybe investment arbitration, commercial arbitration isn't final, and there may be many parallel ways of going about things, and maybe different ways can be used to contest things that used to be thought of as final. But this is a system actually of peer review. In other words, there are multiple centres. There is no longer one centre, and I think this is what we're actually looking at, that there's a whole complex system of balances in which all this is taking place. I think it's very, 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 very important. Thank you very much to the team who's been working very hard. Thank you for the students and anonymous attorneys who asked the question. And thank you to Robert.
Right. As you may know, it's a tradition at White & Case that once the debate has been over, the partner in charge of the arbitration department then spends half an hour summarising what's just been discussed. And if anyone would like to stay here and hear my summary, please stick around. But otherwise, for those who might feel in need of refreshment, there are drinks which are somewhere. Just next door? Okay, so please enjoy our hospitality, won't you? Okay, thanks very much.